Calling civil action 18-4664, Myra Dickert et al. Versus Sanyo Energy USA Corporation et al. Counsel, please approach the podium and state your appearances for the record.
Afternoon. David Singh on behalf of all the defendants.
All right. Thank you, Mr. Singh.
Good afternoon, Your Honor. David Burke-White on behalf of the plaintiffs.
All right. Thank you, Mr. Burke-White.
On behalf of the plaintiffs.
All right. Good afternoon.
Russell Taylor on behalf of the plaintiffs.
All right. Thank you, Mr. Taylor.
Good afternoon. It's John Stratford from Weil, also on behalf of defendants, Your Honor.
All right. Thank you, Ms. Stratford.
Good afternoon. Audrey Stano on behalf of defendants.
All right. Thank you. Just a reminder that we now have, pursuant to the stipulation and the lack of any objection, and pursuant to our pilot project, the cameras are on. I believe they're working. So, but I'm going to do my best to ignore it and let's concentrate on the matter at hand here. I know there's questions about jurisdiction, and I frankly think that's not the nub of this case here. There's some questions I have about the warranty claims, the time bar, the UCL type unfair practices claims that are based on a failure to disclose or misrepresentation. I think those are the key things I really want to talk to you about. So let's talk about the express warranty for a moment. And there is not a claim under the Song-Beverly Act under the Civil Code, right?
That's correct, Your Honor.
There was in the original complaint, and they abandoned it in the amended complaint.
Okay. So are we then governed by the Commercial Code 2313?
Yes, Your Honor.
All right. And so express warranties need not be in writing as is required under the Song-Beverly. It could be oral, but there is a requirement of a degree of specificity, particularly if you're talking about oral representations. And as I understand the oral representations that, and I know they're agency questions, but the oral representations that would have been made by the seller, from what I could tell, were sort of parroting the language from the Sanyo spec sheet about the 20-year power output limited warranty. Were there other specifically alleged statements that were made that would constitute part of an express oral warranty other than kind of repeating what was in the spec sheet? Is there anything?
I don't think so, Your Honor. I think that the spec sheet says limited warranty, 20-year power output guarantee, and I think that the representations of Geogenics, the installer, confirmed that, merely to say this product comes with a 20-year power output warranty, 90% guaranteed power output for the first 10 years and 80% for the second 10 years.
Now, the spec sheet didn't have that level of specificity about the, it just says, well, maybe you can tell me. I mean, when it says limited warranty, it just says power output 20 years, product workmanship 2 years. I don't think it has the same detail as the actual warranty itself that has this little table that shows for the first 10 years, they guarantee 90%, and then from years 10 to 20 it goes to 80%. Am I missing
That's correct. You have that right, Your Honor. I mean, essentially, you know, we're asserting the claim on behalf of the actual limited warranty, and we're asserting the second claim on under 2313 based upon the spec sheet. I did want to indicate again that they were given the specification sheet and not the limited warranty. So this was what their idea of what the warranty was, which came accompanied with the representations from their installer.
So the first question is, in the end, I'm not sure how much difference it makes. Maybe it makes some difference. You've got sort of two bases for a warranty, or maybe three.
Yes.
So the oral representations are kind of tied to the spec sheet.
That's correct, Your Honor.
And the question, the defendants have raised the argument that, well, this is not specific enough. When you have enforcement of an express warranty, there's got to be enough detail in there so you know exactly what the terms are and what's being warranted. And to simply say power output 20 years. We don't know if it's prorated. We don't know if it's percentage, what's covered, what happens if it doesn't meet it, and then product workmanship. That, well, so why don't you answer the question?
Well, I mean,
why would this be sufficiently?
I think those are legitimate questions. I think that they believe that this was the warranty. It's an affirmation and an assurance that there's a 20-year power warranty. The rounding terms, if you will, were representations by their installer. That's what they have. That's it, at least separate from the express warranty. So we felt that based on 2313, that would be enough to assert a claim for the 20-year power warranty, and with the representations in combination with that.
Well, let me ask you, power output, maybe there's a difference here. I mean, power output, that almost calls for some greater specificity, I can understand, because it's not a self-defining term. But when somebody says product workmanship 2 years, that's not uncommon for people on the consumer side to say, well, the workmanship is guaranteed. That means it's got to be in good working order. It's not going to fall apart, and presumably won't delaminate. And why isn't that specific enough? Say, at least for the 2-year part, product workmanship.
Well, I don't think they brought a claim for breach of the workmanship warranty.
Just the output?
It is just the output, and I don't think they could bring a claim for breach of the workmanship 2-year warranty, because we're long past 2 years. Obviously, these products were purchased in, at least allegedly, in 2005, and the statute of limitations with respect to a 2-year warranty or the warranty period with respect to a 2-year warranty would have lapsed a long time ago.
The sale was in 2005?
Correct.
So you are not asserting a 2-year workmanship?
Correct, Your Honor.
Okay, all right. I'd forgotten the time frame. So if we then go to the actual warranty itself, which is quite specific, obviously, the problem there, one is there's a time bar issue, and there's an argument that even though this wasn't provided allegedly to the buyer, if they're going to assert it now, you have to take the good with the bad, and you can't sort of break this up. So if you're going to take the benefits of the limited warranty, you have to also take the burdens, which has a time bar. But it seems to me that the time under sort of time bar rules, statute of limitation rules, the clock doesn't run until there's been a breach. And the breach doesn't occur when the product fails. The breach occurs when there's a failure to abide by the warranty. So if the company says, nope, we're not going to fix it, and communicates that, that's the point where it runs. And at this point, in this case, it appears that a claim was submitted as soon as it was learned that there was a problem, and it took some time for Sanyo to respond, some 18 months or so. And so it was only clear that they would only replace 9 panels, it appears, sometime in mid-2018. After the submission of the warranty claim in 2016, took some time for the process to get through. And so it seems to me that if there was a breach, it would have occurred when Sanyo indicated they would not replace a certain number of panels, and therefore putting it at issue. And that happened in 2018, which would have been within the 1-year limitations period since the complaint was filed in November, or no, even earlier than that.
Yes. I'd like to address that. Thank you, Your Honor. I do agree with that, your characterization. The statute of limitations issues which was raised in the motion to dismiss initially related to the 8 panels that were part of the initial warranty claim. Counsel pointed out that we had not brought a claim within a year of the resolution of that claim. We then pointed out in response to the motion to dismiss that we were not asserting the claim as to the 8 panels that were replaced. As the court correctly says, there were 13 panels in question. From the period of time which they denied the remainder of those 13, if you will, we believe we filed timely. That would be with respect to 5 panels. With respect to, remember there were 43 panels in total. There were 8 replaced. That takes us to 35. So about 35 panels left. And of the remaining panels, the new claim was asserted. The facts relating to it were just a matter of months old, really, because after the replacement of the 8, the powers still began to show problems, and so they asserted this other claim in July of 2018. That claim, I don't think there's even an assertion that there's a statute of limitations issue there. So we concede that there was a statute of limitations as to the 8, and we've withdrawn the claim in the 8, not because of the statute of limitations, simply because they have the new panels and decided not to press on with regard to those replacement panels.
Well, with respect to the other 35, and I don't know if that 35 includes the 5 that had been asserted.
Yes.
So there's sort of 30 new panels.
Yes.
I think the claim there is lack of notice, as I understand, premature.
That's correct, Your Honor.
So there's, I guess, an
I'd
argument.
just clarify.
Yeah.
The terminology is a little bit confused with respect to. I would differentiate. There's notice of breach, but there's also submission of a warranty claim, and we're saying that there's lack of a warranty claim. We're not saying that there's lack of pre-suit breach notice. We're saying they didn't submit the claim in the first place. Two different concepts. Submitting a warranty claim and then later claiming that the warrantor did not honor the warranty, that's the next step, the notice of breach. We're saying there was no warranty claim in the first place or an opportunity to perform.
Oh, well, okay, let's explore that. But before we get there, let's make sure I got my numbers right. So the first 8, or was it 9 or 8?
There's conflicting allegations on that, Your Honor.
All right.
Our records show 8 and 12. There were 8 that were replaced, and 12 out of 12 in the original July 2016 warranty claim. But there are allegations in the complaint of 9 and 13. I don't know that it's material for purposes of
Well,
deciding.
whatever it is, whether it's 4 or 5 panels of the original 12 or 13, there's not a statute of limitations, a bar, time bar on that you're asserting on, as to those, correct? We're
not asserting a statute of limitations bar with respect to the purported warranty claim in July 2018.
Right. All right. And as to the other ones that weren't part of the original 12 or 13, that now sort of newly discovered panels, your claims that there's not been a warranty claim submitted.
Correct.
And so that's distinguishable from the pre-suit notice. So the lack of warranty claim, what is the legal source of the obligation for warranty claim? Is that in the contract, or is that in the commercial code, or what?
It's in the contract, Your Honor. Paragraph 5 of the limited warranty, which is attached as an exhibit to the complaint,
Okay.
provides a notification requirement. And it provides not only that there's a notification requirement, it indicates to whom notification must be provided. It provides an address to whom notification must be provided, and it specifies that claims must accompany evidence of product purchase date by the customer, which we don't believe that the July 2018 letter is a warranty claim within the meaning, within the confines of paragraph 5 of the limited warranty. We do have it available to put up on screen, and I would like to be able to walk through it with Your Honor, so I could walk through many of the reasons why we don't believe it's a warranty claim.
All right, we'll do that, but I just want to make sure I understand. So the requirement of pre-suit notice that is required under Commercial Code 26073A or under the CLRA, that's not the issue.
No, the issue is whether they submitted a warranty claim as required under paragraph 5 of the limited warranty. And I do have a case on point which recognizes that it is a prerequisite to fulfill notice requirements of a warranty claim as required under the terms of a warranty. We cited in our brief, it's Otto versus Arco error, 2017 Westlaw 372975. In that case, the plaintiffs tried to argue that a CLRA notice, like the notice here, constituted a warranty claim, notice of a warranty claim, and the court held no, because the warranty notice requirement in the contracted issue required identifying specific products, but the letter itself, the CLRA letter, did not identify specific products. So there was a failure of a condition precedent in the notice requirement.
So this is a contract matter, not a statutory matter.
Correct.
And the contract provision is Section 5. And if you want to then tick off what it is about the July 18th letter that is deficient, that'll be helpful.
Sure. And if my colleague can pull that up on the screen, I hope this works well with the video.
Okay.
Initially, if you, does Your Honor have it before him?
Yep.
Before you? Initially, if you look at the address to whom this July 18th, 2018 letter was addressed to, it's to a Sanyo North America Corporation Solar Division address in Cupertino. If you compare that to the address in paragraph 5 of the limited warranty, it's a different address. And in fact, if you look at the allegations in plaintiff's first amended complaint, they acknowledge that this Sanyo entity didn't even exist in July of 2018. This was a defunct address that they sent the letter to, and it simply couldn't have constituted notice to the proper parties. In light of the fact that, as I'm sure Mr. Berkowitz's diligence in connection with the lawsuit showed, because he alleged it just a matter of 2 weeks later, that Sanyo entity was non-existent in 2018. On top of that, it's particularly puzzling that they would send a warranty claim to this address, being that the plaintiffs had actually submitted a warranty claim 2 years earlier in July of 2016, and they had submitted it to the proper Sanyo address and had dealt with Panasonic, which was the successor to the warranty program, and they knew who to send it to at Panasonic, who was honoring the warranty program. So it's very odd that this letter, this seems more like a check-the-box CLRA notice than a true warranty claim to us. Beyond that, if you look at the various sections...
Do we have any idea what happened to this letter at this address? It's a defunct address, but does it get forwarded?
Attached. We're including it here because it was attached to the complaint.
But, I mean, do we know whether it was then forwarded, or did it just get returned?
I don't know offhand, Your Honor, one way or another.
It says via certified mail return receipt requested. Presumably, they didn't get return receipt.
I don't know.
Do you know, counsel?
Yes, we did. I have it with me, Your Honor. I didn't attach it to the complaint. We sent it to an address. We thought that the governing warranty at the time, which we apparently were incorrect according to counsel, which he sent over after we filed this lawsuit, we thought that the appropriate address was the address we sent it to, the Sanyo North America Corporation in Cupertino.
So what happened to the letter, given that you sent it by return receipt?
We sent it to them. They received it. And
received it at that address?
Yes, at that address. And by the way, Your Honor, just
who was at that address?
Panasonic. That's a Panasonic headquarters. So while he argues this is some sort of defunct address, that is a very generous way of putting it. It actually wasn't a defunct address at all. It was the address of Panasonic. They may not call it Sanyo any longer. They didn't even bother to have a forwarding address. So what we did is deliver it to Panasonic directly, and there was no question at that time that was a division of Panasonic that was dealing with products, and that the notion that they didn't actually receive the notice by virtue of it going to a Panasonic headquarters, if you will, is a strange credulity.
Right. So you have evidence that it was received by Panasonic at this address?
Yes, I have it with me, a signed certification.
All right. So let's go to the next issue.
Okay, the next issue, and just to address that briefly, it isn't the address specified in the contractual provision. There is a Sanyo address that's specified in the contractual provision in paragraph 5. That is not the address that they sent this letter to. I don't know.
And that's going to raise the question whether is there a doctrine of sort of substantial compliance? Is there a doctrine of so what?
I don't believe the plaintiffs have argued that thus far, but there is not substantial compliance, and I can walk through the other reasons, Your Honor.
Yeah, let's go through the other ones.
So the letter is divided into 3 parts. If you go into the first part of the letter, it's, I think plaintiffs would agree, the first part of the letter is a CLRA notice. And if you look at the end of the CLRA notice section, which is on paragraph highlighted here on page 2, the plaintiffs asked for some relief in connection with their CLRA notice. And they asked for relief on behalf of all consumers in California for all products installed in California or sold in California. And that's the only relief that they asked for in the entire first third of their letter, is relief with respect to California consumers. That's critical here, Your Honor, because neither of the Dickerts, the two named plaintiffs, are consumers in California, and they didn't even allegedly purchase their solar panels in California. So there's no request for relief with respect to the Dickerts at all in this CLRA notice. So that's the first third of the letter. The second third of the letter is labeled itself, Notice of Breach of Warranty. This isn't a warranty claim. This is claiming that we've already breached the warranty, but it's putting the cart before the horse. They never actually submit the warranty claim and provide us an opportunity to perform. They jumped right to the end of sue first, ask questions later by asserting a warranty claim, and then they claim we get 30 days, by the way, to respond to the CLRA notice in the prior paragraph, but they filed suit 15 days later. Rather than waiting the 30 days. With respect to the notice of breach, if you look at this section as well, they don't indicate what panels allegedly have a problem. Paragraph 5 of the limited warranty also specifies that they have to provide accompanying evidence, and this is quoting, Your Honor, claims must accompany evidence of the product purchase date by the customer. They didn't provide any evidence of the product purchase date, any evidence in connection with this section or anywhere else in this letter that would constitute, satisfy that condition precedent in paragraph 5 of the limited warranty.
Well, in the first part, which you call the CLRA part,
Yep.
Page 2, third full paragraph down, does describe that describes what they are, 43 HIP 200 BA3 Sanyo installed at the Dickerson's address, and it gives an address, and it says they purchased the panels on or about September 19th, 2005, and then describes what problems were with the 8, et cetera, et cetera. So it does give a date with respect to those 43 panels, what they are, where they are, and when they were purchased.
I don't believe it identifies, it doesn't accompany evidence of the product purchase date, nor do they identify the specific panels that they're claiming for here. I believe, I've got to find the language, that it says that many of these panels experience, there we go. In the paragraph that you're referring to, it says many others, at least 8 solar panels have failed, and many others have experienced power degradation below 80%. They don't identify which of the many other panels they're
in
claiming
order to
for here.
fulfill paragraph 5, they would have to go up there on the roof or wherever these things are and get serial numbers, or how would you?
That's typically how it happens. And here in the first amended complaint, they allege that an inspection took place by their third-party contractor, a company named Power Overhaul, conducted an inspection. They allege that inspection took place on November 17th. This is set forth in paragraph 47 of the first amended complaint, Your Honor. That's they claim that that's where they identified the panel showing the additional delamination. The paragraphs that you're referring to in the CLRA letter here, those 8 panels are the time-barred ones.
Yeah.
So the additional panels weren't identified until an inspection on November 17th, 2018, which is another reason why this letter can't be a warranty claim, because their evidence of delamination with respect to the additional panels.
The inspection was November
17th, 2018. It's set forth in paragraph 47 of the first amended complaint. It makes absolutely no sense, Your Honor, that something that was discovered, this additional delamination, 4 months after the July letter, could have somehow been covered by the July 2018 CLRA, this July 2018 notice.
Did Panasonic or Sanyo reply to this letter saying, well, tell us more specifically how many and which panels?
I don't know that. His telling me that they received it is the first I'm hearing of that, I don't believe there was any response to this letter.
Is it your contention that Panasonic never received this letter?
I think the law firm did. We saw it in the complaint at the very least. I don't know if they received it separate and apart. I don't know one way or another.
All right. What's your response?
Thank you, Your Honor. Well, there was a few things there. I do want to mention, of course, the Dickerts are retired. They are consumers, and they are remote buyers. Under Greenman and Tayson, the case which you handled, it's quite clear that the Supreme Court has said notice is not required for a breach of warranty to a remote consumer.
Although it's a little different when the remote consumer finds out exactly who the manufacturer is and has correspondence with the manufacturer.
Yeah,
It's a little different than, you buy some from
Well, it's a point well taken, but I think that we've satisfied that as well, too, Your Honor. The allegations of the complaint make clear that they went through 18 months of absolute hell trying to get this claim through, and they were dealing with an individual, and we've made allege this, that was non-responsive. They made many, 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 many calls. Counsel says that's the proper channel. You must give it to this person who is an assistant, had no authority, told her this many, many times. It's in the complaint. So there was this revolving cycle of trying to directly communicate, and their installers trying to gather more information, this undescribed information that they wanted, and it just went on and on and on. So,
are you saying that excuses compliance with the paragraph 5?
No, I'm not. No, what I'm saying is that we handled it a little differently. What I'm saying is that two things: they continue to be a remote purchaser. Greenman doesn't say that if you're a remote purchaser and that if you have interactions later on, that suddenly if you have a secondary complaint, you must give them official notice, which you otherwise didn't have.
Well, I thought we were outside the statute. I thought I heard from the defendant they're not asserting a statutory pre-suit notice problem. What they're saying is that it's actually just compliance with the limited warranty, paragraph 5. So regardless, you don't need the remote. We don't need to debate the remote buyer doctrine.
Okay, good.
This is just a simple, in a way, it's a simple contract question.
Okay, fair enough. So remember, and we have allegations in the complaint of this. They didn't have this. They didn't have this notice. They didn't have this express warranty. There's also a series of allegations in the complaint that they categorically didn't deliver this warranty. In this case alone, they didn't give it to the installer. They didn't give it to the distributor. They didn't give it to anybody in the chain.
When did they get a hold of this warranty?
I got this warranty from counsel. The only
as of July, when the July 18th date.
No, it
was not in the.
We didn't have that at that time. We went investigating through someplace. I don't even know if it was online or where, and we came up with another Sanyo / Panasonic warranty, which we believed governed this panels, and apparently they have certain models that go to certain warranties, even though the warranties are almost identical.
When did you or your clients obtain the actual warranty?
The actual warranty was after counsel appeared, and counsel took exception to some language that we had quoted in our initial complaint, saying, "I'm not sure which warranty you quoted," and I said, "Well, what warranty?"
About when was that?
That would have been in I think we first spoke in September of 2018. I can give you the exact date. I think it was like September 7th, 2018, which would have been, a month and a half after we filed this notice. So it was then that he said, "No, okay, here's the actual one."
Did you then attempt to refile another or send another warranty claim?
No, Your Honor, we didn't attempt to do that. We felt, frankly, that our initial effort, which was where they instructed people to submit warranty claims, true enough, Your Honor, it was a different address. It was for warranty claims. We felt that was adequate. But if I may add one other thing, Your Honor.
Where did you get the first, when you said we were just doing what they said, that was when you had a different warranty in your hand?
Yeah.
You thought,
again, as I said, our client didn't have the warranty. She had the spec sheet.
So you had another thing that looked like this? Was for different?
Yeah, we did. We have it right here. It almost looks identical. It's a different format, and it's.
Can Mr. Berkoway please put in the record what model that warranty refers to?
Yeah, I'd be happy to do that, Counsel. But admittedly, it's a different warranty that relates to a different Sanyo panel. Don't even know which Sanyo panel this exactly is. It calls it a DA03. And so, but we felt that this was representative. It explained where and how you could get a hold of Sanyo, and we wanted, Your Honor, and this is important, I think, we did not want to call this fellow up we'd had trouble with for 18 months and to say, oh, by the way, we still have trouble. That's what they had been doing for a year and a half with very little.
Well, are you saying that because of his non-cooperation?
His non-cooperation.
That excused compliance with
No.
paragraph 5?
No.
What's the relevance of the fact that you had a point of contact that wasn't particularly cooperative in terms of fulfilling paragraph 5?
We felt we did not have any belief that this would be the person to whom you would actually submit another complaint, because he was non-responsive and repeatedly said, I have no authority. This is not up to me. This has to go back to Japan. They have meetings periodically. They tell me based on what I tell them. So I can't do anything about it. And by the way, Your Honor, I spoke with this gentleman personally. So in a part of our investigation, I spoke to him, and those are not conjectures. That was part.
I understand it, but I'm not sure I understand what's the relevance of that to compliance with contractual obligations.
I think, well,
are you saying it relieves your
we
client?
didn't have this address.
All right, so you didn't have it. So that's one
We didn't
issue.
have this warranty.
Let me ask you this: the warranty claim that you do have that had a different address for a
Yes.
different model, did it also say that claims must accompany evidence of product purchase date by the customer?
Yeah, that's a good question. And I think it does. Let's see. Bear with me, Your Honor. Obtaining warranty performance. Here's identical language. Customers who believe they have a justified claim, I think it's important. Customers who believe they have a justified claim covered by this limited warranty. In the warranty that covers this case, exact words, customers who believe they have a justified claim covered by this limited warranty must immediately notify an authorized Sanyo representative or contact Sanyo directly by writing to. Now, this is another thing. Immediately notify an authorized Sanyo representative.
All right, so there's some looseness there.
course there
That's
is.
in the disjunctive.
Yes, and then
Then it has a different address.
different address. And we think Panasonic would be their authorized representative, and that's where we got it to. But here's the same language. Claims must accompany evidence of the product purchase date.
All right, so that's the same. So one of their arguments is, well, even though you had the date of purchase and the model, there was no, quote, evidence of the product purchase date.
My response to that, Your Honor, is that's not what the warranty says. What do we mean by evidence? Evidence of the purchase date is a statement in our letter that says this is the date we purchased them on. That is evidence of the purchase date. And by the way, it's exactly correct. And what do they want that information for? They obviously want to know if they could find out what panels have problems. We gave them not only the exact date in which they purchased, Your Honor, they seem to overlook the fact, because they say it was in the CLO portion of the letter, that we gave them a precise description of what our claim was. You replaced 8 panels. We have a degradation of power as the rest. They're unsafe. They're a fire hazard. We don't know exactly which of the remaining panels are falling below the 80%. What we know is we have a power degradation claim, and we gave them all of that information. So our position is we sent it to an address, as they say right here, which would be, an authorized Sanyo representative. How could Panasonic and that address for the warranty claims not be an acceptable place? They acknowledged receipt of it. They got actual receipt of it, and we told them exactly.
All right, let me ask 2 questions. One, do you question whether the address that was actually used here, the Cupertino address, was in fact the Panasonic headquarters?
I have no idea offhand.
You don't know one way or the other?
I don't know one way or the other.
Okay. let me ask you this. When it says claims must accompany evidence of the product purchase date, what does that mean? If they give you the information about who bought it, what model, and the date.
Yeah, in practice, what ordinarily happens is there are pictures taken of the serial number on each panel, and that's provided. That's, in fact, what would happen with respect to the 8 replaced panels previously. There were pictures taken by Power Overhaul with respect to the serial numbers.
Well, if you had that information because of the prior back and forth
that was
and the repair.
That was the
8. But it said all these panels were all purchased at the same time for the same location on or about September 19th. So if you knew, and it says at least 8 of the panels and many others, presumably in the same lot, have experienced power degradation. So your client obviously knew the origins and the details of the 8 because they replaced those. So why do they need, to be frank, I mean, why do you need such technical? They've identified where it is. They've identified who it is. They've never went to practice. They've already sent back 8 of the 43. You knew it was from the same period of time. You want the consumer has to climb up on the roof now and try to find a serial number and unscrew the thing from the.
I think the fundamental problem is what is the purpose of a warranty claim? The purpose of the warranty claim is to give us an opportunity to perform.
Yes.
From receiving this letter, how would Panasonic know which panels they're asking to be replaced? From receiving this letter.
Well, if you're a homeowner and you've got 43 panels and you know that in the aggregate there are problems.
So they say many of the products, just looking at the, at least 8 solar panels have failed and many others have experienced power delay.
Many others of the 43 that were all purchased on the same date.
So how would we know which of the 43?
Because paragraph 2 says that upon receipt of a claim, warranty claim, Sanyo or its designated representative shall conduct measurements to determine the actual output of the products. So you know that of the remaining 35, it's asserted that there's a claim. They don't have to prove beyond reasonable doubt that there was always a problem. They think there's a problem. And then somebody's got to do the investigation. And this, at least, can be read. Again, we're in the process of this motion to dismiss, right? Yeah. So, and you have all inferences to be drawn in favor of the non-moving party, and you have the rule that written contracts will be construed against those who drafted it. So one could certainly construe this to mean, I'm not saying this is the way it will be construed, but one could construe this to mean that once you receive a warranty claim, which is based on someone believing they have a justified claim covered by the limited warranty, Sanyo will go take the measurements and find out whether there is a problem. It may end up there's no problem at all.
A little bit circular, but the obligation to conduct, even under plaintiff's interpretation of the language triggering the alleged obligation to do measurement, is only triggered upon receipt of a warranty claim. So obviously your analysis as to whether this was a warranty claim is dispositive of whether they can even.
Well, you're the one that said it was circular, and I'm saying it's not so circular because once somebody, presumably at least in good faith, believe they have a warranty claim, and they give you the basic information. They make sure it's not 40 years old, make sure they give you the model number, the date, and they describe what the problems are. I mean, then it seems to me there's enough of a prima facie case, at least arguably under this terms of the warranty, that Sanyo would then have the obligation to go out and determine whether or not the power output meets the table.
All we're asking for, Your Honor, is an opportunity to perform under the terms of the warranty. Dismissing this claim without prejudice, and I'm not saying that any of the this is a live warranty. This is a warranty that will last for 20 years. If they provide us notice, an actual warranty claim, tell us which panels. They apparently have pictures of which ones have delamination. They haven't given them to us. They reference that in paragraph 47 of their first amended complaint. We will, in good faith, our clients will, in good faith, respond to their warranty claim. This is all about trying to check a box so they could bring a lawsuit rather than give us an actual opportunity to perform. With respect to the first warranty claim, which actually was a properly submitted warranty claim pursuant to these procedures.
Well, what has Sanyo / Panasonic done since, number one, having knowledge of this, whenever you got knowledge of this July 18th letter, certainly knowledge of the suit. You got knowledge of it when the suit was filed shortly thereafter, so you, this was an exhibit. What has Sanyo or Panasonic done in terms of responding to this claim about the 43?
So the November first amended complaint was the first time that they told us that there is an additional delamination problem with respect to other panels other than the 12 panels in their original warranty claim.
So the first complaint did not attach this July 18th notice?
I don't recall.
He didn't answer your question, Your Honor.
Well, let me ask you, predicate to that, did the first complaint attach the July 18th notice?
Yes.
Okay.
The July 18th notice doesn't raise the issue of additional delamination on other products.
Okay, not delamination, but it says there's a problem. Maybe not delamination.
The problem they're identifying is delamination. That's their alleged defect.
But there is a problem. They've identified that they're experiencing power degradation.
Because of they're alleging that it's associated with the delamination.
Okay, but having notice, if this were sent to the right address and they had identified by serial number all 40 or 35, you would concede that would be enough.
I would concede that would be enough to let Panasonic make a decision as to what to do with respect to the warranty claims. And then once they received a response from Panasonic, then they can either sort of claim a notice of breach or not but we have to have the opportunity to perform.
Right. Did Sanyo make any attempt to go out and actually measure the actual power output of the products?
We have not. We don't believe that this is a warranty. This was a warranty. We didn't construe the CLRA letter demanding that we replace every panel in California.
Well, if you do so at some point, it's at your peril, because at some point you can argue about the timeliness of it, but it should have become clear to somebody that this is a warranty claim. They're saying because it says we want these things to be fixed. Now they said 30 days. But
if you want us to construe the lawsuit as or the where they raise the allegation of additional delamination in paragraph 47 as a warranty claim itself, does that mean that we have the opportunity now, Your Honor?
All right, let me ask you this: does the material breach doctrine apply to the paragraph 5?
I haven't seen case law on that, but plaintiffs do not cite any case law on that. They never argued that in response to our papers. I believe it would not. I believe it would be a material breach to not send notice through the proper channels, because it risks the letter getting lost somewhere, not actually making it to the decision makers with respect to warranty claims. And there's a reason they specify. Also, Mr. Berkowit's argument that they had dealt with the person at Panasonic who had assumed control of the warranty program. He didn't like the responses, apparently, from that person, but he's making almost a futility argument, not an argument that he didn't know the right person to send notice to, who was the authorized Sanyo agent. He knew the right person.
That's why I'm not really focusing on that. You say you have the proof of a receipt.
Yes, Your Honor.
Can I see that?
Copies for counsel as well.
Why don't you give counsel a copy and let me look at...
Look at that, Your Honor, if I may. I can elaborate a bit. So you'll see the address to which we sent it to says Sanyo North America Corporation Solar Division. It's important to say the next point says Solar Product Warranty Claim. That's on the envelope. It was signed, and you'll see the delivery slip on the right-hand bottom side on July 23rd. The letters dated the July 18th. It was signed on July 23rd, and of course the letters attached. Now I do want to point out a couple of other things, so there's no question what this was. The top of the letter, it says Notice of Violation of Consumer Legal Remedies Act and Notice of Violation of Consumer Legal Remedies Act and breach of warranty. Then it addresses whomever this is going to read this right at the top of the letter. Again, it says attention, Sanyo product warranty claim, and then again in the body of the letter at the bottom of the second page, it says notice of breach of warranty, and it's not, and if you'll see it, Your Honor, it says a breach of express warranty and merchantability and fitness of use, and further constitutes a notice of breach of warranty of express warranty on Song Beverly. Yes, we didn't insert that now. Magnuson Moss, California warranty law, New Jersey warranty law, and the warranty laws of all states in which Sanyo product is sold or installed. I'm going to end by this, Your Honor. If the notion that you can split a claim by saying, oh, you gave us notice that you're unhappy, which, by the way, as you know, in the case that you've written, a tissue, a scribbled note on a piece of tissue paper would be adequate. Well, no, properly understood, that's not adequate. You're not to just tell the person that you have a note or a claim. You are to define that claim with such specificity that goes into every panel, every serial number, everything you could probably say about it before they're on notice that they need to respond to you. Who signed this, Your Honor? You started raising the correct questions. Who signed this? What did they do? What happened with this claim? Did they notify their claims department? Did they notify that gentleman who had been working with them for a couple of years? I can tell you right now, they did nothing. Here's how we know. We had difficulty serving Sanyo, and that had to do with their various changes in names and so forth. So although we filed this complaint on the 2nd of August, we couldn't serve Sanyo until August 30th. By the way, the service date is in your record, Your Honor. The proof of service, I think, is I think it's August 30th. So in fact, before Sanyo even knew this case was filed, they had 43 days.
Is the date of service in the record?
Yes, it is. August 30th.
Your proof of service was filed with the court?
Yes, it is, Your Honor.
You know what docket number that is?
Yes, I think I do. It was early on. It was around August. Give me a second. Here we go. I have it here. The proof of service on Sanyo North America was document 13, filed September 10th, 18. And the proof of service on Sanyo Energy was document 14, also filed on September 10th.
And they show August 30th service date?
They say, it says August 28th, received by me on August 28th. But there's one qualifying factor. This me is the Secretary of State. So we had to serve it through the Secretary of State. We served the Secretary of State, and then the Secretary of State, you'll see in these documents, they're the ones that serve Sanyo, and that service, I believe, actually took place on the 31st of August. Yes, 31st of August, at least this one. So the point, if I may, counsel, the point is, Your Honor, if the issue here is their lost opportunity to cure, which they appear so intent on wanting to do, yet we haven't seen one piece of evidence thus far, why on earth would you wait 43 days after you were served with a notice and do absolutely nothing?
Well, the simpler question here is whether paragraph 5 was either substantially complied with or whether there was a material breach, it seems to me. And now, you did not append this or allege this service successful mailing in your complaint, nor, and so we may have to address that.
Your Honor, just if I may briefly address the couple of last points that he raised. With respect to service on Sanyo via the Secretary of State in California, the complaint itself alleges, as it acknowledges, Sanyo didn't even exist. These entities didn't even exist at the time that they sent this purported service. It makes no sense that they're claiming that provided notification to a non-existent company that had dissolved before they had submitted any of these warranty claims. They had merged into the FAC specifically alleges.
Well, do you think it would be relevant whether or not it actually found its way to the proper party, i.e. Panasonic?
If it made its way to the decision makers Panasonic's a big company. Depends who it makes it to, and whether if it makes it to somebody who is in charge of making warranty decisions, or if it makes it to like a secretary somewhere and never makes it to the proper warranty channels, the people who actually have the opportunity to consider warranty claims, I think it matters who it went to, not just if it went to.
And that goes why I use the term substantial compliance or material breach. If it never got there because the address was so bad, That's hardly notice. On the other hand, if it actually got there because it had written all over it, warranty claim, warranty department, all that sort of stuff, then maybe there is. But depending on what, it seems to me that this fact here ought to be something that's alleged or submitted as part of the complaint because it's not in the complaint at this point. So now the question is now teed up whether or not there's been either compliance, substantial compliance, or something of that ilk with respect to paragraph 5.
If they
And we don't know who received it at this point, but if it is delivered with these markings, one can draw a reasonable inference that it was received. Now, should it prove not to be true, then there could be a problem. It's not like this issue just goes away. This is still a potential defense. But for purpose of 12b-6, if there is a proper allegation upon which it could be plausibly determined or found as a matter of inference that it got to the proper department, the gist, and same thing with whether you provided a receipt or a photo or a very good description of the panels, when they were bought, where they were bought, by whom they were bought, and knowing that the company already had 8 of the same lot, one could argue, well, it's superfluous to actually provide the receipt or photocopy. There's enough there for Sanyo to take the next step. So there are a number of questions, but it seems to me that if there's I think delivery is the bigger question, as I'm seeing it, at least at the 12b-6 stage. That's not to say that issue disappears.
Thank you, Your Honor.
So let me turn to the other question. There's a lot of questions I know, and we only have limited time, but I want to ask about the misrepresentation theory here and what was not alleged. And as I understand it, the theory is there's both some affirmative misrepresentations, but there's probably the major omission has to do with the quality of the solar panels, the fact that they were subject to delamination, and which could raise safety concerns and fire concerns and shock concerns, this sort of thing, and that this wasn't disclosed. Is that a fair summary of your?
I think that's part of it, yes, Your Honor. Delamination is certainly part of it.
And one of the counter arguments to that, as I understand the defense position, is that to plead the circumstances of omission with enough specificity, you have to describe the content of the omission and where the omitted information should or could have been revealed. There's some details that you need to supply. And so what's your response to that? What is it that they should have done with respect to the quality, delamination, shock, potential safety concern? What should have been disclosed and where should have been?
I'm sorry, I thought you were asking him a question. Could you repeat
I'm
the question?
asking you
Okay,
that
what was the question, Sharon? Sorry.
With respect to the allegation of an omission, failure to disclose the defect of these, the delamination and the consequences such as shock and stuff, what should have been disclosed and where do you contend that should have been disclosed? Because that's one of the, at least some cases suggest that's an element of a failure to disclose. You got to have some specificity as to, well, where should have been disclosed? In some brochure, or how would that have been disclosed?
Well, I think in these sorts of situations, it's difficult to prove that they knew at the time of the sale. Let's speak candidly. What happened here, we're convinced, is that they learned of it shortly thereafter. I don't know whether that's before or after our client purchased. That's true. But this is a class action, and we make this allegation on behalf of the class. What we're saying, Your Honor, is that when you learn of a defect that has the sort of ramifications, the fire hazards and safety risks that this defect does, which, by the way, is prevalent, it's not isolated, you have a duty to disclose. And so part of what we're saying in this UCL is that they have an obligation to disclose.
When did they know? Where does the complaint state the point at which Sanyo or Panasonic had enough knowledge that it should have been disclosed.
I don't think we actually make it very clear, Your Honor, to be perfectly honest.
So how can you find a duty to disclose? You got to have knowledge of it first. I mean, before you have a duty to disclose, that's what makes it fraudulent.
True.
So without knowing, I mean, if they only discover this after the fact, then you can't say that, well, they should have disclosed it at the point of sale back in 2005 if they didn't know. So it's hard to make a claim based on fraud.
Yes.
So at this point, you don't know when they
I don't know, and frankly, I don't feel that's the gravamen of our case, that they knew before they sold it that they had a delamination problem, and they went forth and nonetheless sold it anyway. It's different than that they learned of that. We don't know the day they learned of it, but we do know it's years ago, and our claim is that they have an obligation to disclose that actively at this point. And when people make a claim, and this is the activity we're trying to stop, is that the warranty makes very clear, Your Honor, that they guarantee 80% output for 20 years. And it makes abundantly clear in language that is not vague in any way. Upon receipt of a warranty claim, Sanyo or its designated representative shall conduct measurements to determine the actual power output. And again, not to repeat, and I know we're running out of time, but in terms of the notice, customers who believe they have a justified claim, that is a subjective justified claim, can submit a claim to an authorized Sanyo representative, who we contend is Panasonic. And by the way, Sanyo didn't disappear. They're not defunct. They apparently don't have forwarding addresses, but they're part of Panasonic. So to say they're defunct, that's simply not true. They are.
If you're claiming some form of misrepresentation other than the quality, which is now going forward, not backwards, because there's no evidence. You're also claiming misrepresentation as the scope of the limited warranty. What's the misrepresentation with respect to the warranty? The warranty is laid out here. I mean, you're claiming there were some misrepresentations that counter to the terms of the written warranty?
No. I don't think we're claiming misrepresentations counter to the warranty. I think what we're claiming, the essence of our case, is that there is a warranty suppression case. There is a breach of warranty. The panels are not performing as they had promised. There's no question about that. But in terms of how they're now enforcing the warranty, is they're telling people that it's the people themselves that have to conduct the tests, and that in order to trigger a warranty claim, you have to come in with a substantial amount of information, which, by the way, pursuant to these standard test conditions, the only way you can show 80% is to loss is submit them pursuant to standard test conditions.
In other words, according to your allegations, they are construing paragraph 5 to require the evidence of or somehow they're construing it to require that the consumer produce the test results in order to even file a warranty claim?
Precisely. And
where is that allegation?
Where is that allegation?
Where is that assertion to consumers being made, and where is the allegation in the complaint?
Where is it being made? It is being made when a warranty claim is being asserted. And we say that, we have said that, and this is our allegation in paragraph 72, that plaintiffs long ago submitted its warranty claim to Sanyo. Sanyo has refused and continues to refuse to inspect plaintiff's solar system. They've never been out there once. And class member solar systems to conduct measurements, quote, to determine the actual power output of the products. I can't say it more clearly. They promised to perform the tests if you in good faith submitted a claim.
Can I interject?
Our people have in good faith submitted a claim. They're refusing to perform the test. What's the reason for that is they're expensive and complicated. To put a homeowner into that situation is dangerous and causes, not only great expense to them because they can't do it themselves. If I may, Your Honor, I appreciate.
But why isn't that a breach of the warranty why is that a misrepresentation claim?
Because they say in the warranty, I think this is UCL. They're breaching the warranty by not performing the tests. They're supposed to perform the tests, so that's the breach. But in terms of a misrepresentation, they say they're going to perform the tests, and they don't perform the tests. That's a blatant misrepresentation.
Well, so you're using the representation in the warranty as both the basis for a breach claim, breach of warranty claim, as well as a misrepresentation claim.
Yeah.
There's not, you're not claiming other collateral statements that are misrepresentation. It is in the warranty itself that says we're going to take the measurements, and in fact they don't take the measurements.
Yes.
So you're saying simultaneously that is both misrepresentation and a breach of contract.
Yes, Your Honor. And the only other element is that I think that once a person submits a claim, they have a duty to disclose. They can't just send the consumer down this primrose path. It's sort of like going to the, you buy a car, you submit it, you go to have a warranty claim, you go check your engine, and they say, by the way, we'll look at your engine, but you got to go figure out what's wrong with it. Even though we say in the warranty, we'll figure out what's wrong with it, you go do it, and we won't even consider whether you have a warranty issue with your car until you prove what's wrong with it. That's what they.
I understand the argument.
Okay.
I was just trying to understand what your misrepresentation claim is.
Thank you, Your Honor.
All right.
If I may, Your Honor,
Yep.
With respect to the purported misrepresentation about the terms of the warranty, they don't identify any of the 9B factors. He's describing it himself as a misrepresentation claim. 9B clearly applies. The circumstances of the fraud have to be alleged with particularity. There's no who, what, where, when, why, how with respect to that allegation, including in the paragraph 72 that he just referenced.
All right. Now, if he were to make it more explicit that the alleged misrepresentation is, and he quotes, we will, come out and measure and blah, 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 and there's no intent to do that, et cetera, what's your view about whether one can assert both, the same statement could be both a breach of contract as well as essentially a fraud claim?
My view is maybe under the UCL, the borrowing prong, they may be able to assert that it's an unlawful to the extent that if they actually prevail on a breach of contract claim, they could probably piggyback with respect to, I'd concede that they could probably piggyback with respect to stating an unlawful
And the same
claim.
statement also constitute misrepresentation if there is no intent to.
I think intent is obviously required with respect to any concealment or misrepresentation. They do have to. With respect to concealment, Your Honor has an excellent decision in the Ford One Touch, the Touchstar case. You actually said in that case at the end when you were dismissing an unjust enrichment claim, the failure to identify the timing of knowledge can actually be dispositive as to the unjust enrichment claim. There are a lot of other cases finding that it could be dispositive to UCL claims because you have to establish a duty to disclose.
Well, that's what we just talked about. I think counsel conceded that he doesn't have a claim of knowledge of delamination. He's not claiming that Sanyo had that knowledge at the time they sold this, and they sold it notwithstanding knowing
it has ripple effects, though, because once you take away the timing of the knowledge, if they can't pinpoint that Sanyo did anything wrong, i.e. at the time of sale it knew of the purported defect, then what conduct are they pointing to as to Sanyo that was wrong? The complaint itself alleges that Sanyo was defunct by the time Panasonic was the one that received the warranty claims and agreed to honor or not honor.
Well, it sounds like what he calls the warranty suppression conduct is now conduct by Panasonic.
Yeah, it depends on the timing.
Having inherited these warranty claims, they are now trying to foist upon consumers all sorts of, or a huge requirement that they basically prove the power output with their own testing outfit before Sanyo would even consider a warranty claim.
I think that is an accurate description of his representation, but the reason timing matters is because if it was Panasonic that they're alleging was the bad actor, then there's no California-related activity in this case. If the original sale itself is not unlawful because Sanyo didn't have knowledge of the purported defect, and the warranty suppression was by Panasonic, which is a New Jersey corporation, not in California, then they haven't identified any California-based activity that underlying the wrongful conduct that's alleged with respect to any of their claims in the case. And as a result of that, there's plenty of cases saying that the UCL and CLRA, the presumption is they can't be applied extraterritorially to a consumer to a resident, non-California resident. And so the timing of everything really matters. Who are they alleging the unlawful conduct by? Because Sanyo is allegedly their principal place of business.
All right, well, let me ask. To the extent it is now some of this conduct that's alleged in a complaint is Panasonic's policy of warranty suppression. We're past the Sanyo merger. What's the jurisdictional tie then to California?
Well, I think that Panasonic is responsible for the activities of Sanyo, first of all, when Sanyo merges into Panasonic.
Well, but this is new conduct. This is, hey, we got the warranty. Everything's okay, except now we got a new policy of saying, well, notwithstanding this thing, you, consumer, got to prove these measurements before we'll even consider this a warranty claim. You don't want to get in the front door. We're not going to fix your car, or you look at it until you prove from the mechanic it's already fixed. That is given the time frame of all this, that is now a Panasonic decision. So what is the California basis of jurisdiction on that? That's different from the original breach of warranty.
Well, I think I try to respond to that, and I might have a young counsel with me today address part of that point.
Good. We encourage young counsels.
Yeah, I know.
So might as well get the real.
He's better than me in this topic. His name is Russ Taylor. He's from Farella, Braun, and Martel. He's was admitted to Colorado in 2016 and California 2017. He clerked for the 10th Circuit.
Good. He can come on up.
And he also clerked for the Colorado Supreme Court.
All right. Then you can explain to me the jurisdictional basis.
I'd say one thing before I defer, is that this pattern in practice has extended from Sanyo and into Panasonic. It is not a new act.
Well, when was the merger?
I believe they identified 2009 in the complaint.
Yeah. So the way warranties are handled, this has all been post-merger. The warranty was issued by Sanyo. I understand that, and I understand that notion that the breach, the warranty was extended, et cetera, et cetera. But now you're talking about misrepresentation and telling people, one thing that's different from what the representation was. So the culpable conduct is now that which belongs to Panasonic. So assuming that's the case, what is the basis for California jurisdiction?
Your Honor, thank you for the opportunity.
Yes.
I actually don't think that timing matters quite as much, because under Delaware law, which is the law of the state of a corporation, all of Sanyo's misconduct is imputed to Panasonic. We make that point up front in our opposition brief. Opposing counsel hasn't cited to any Delaware cases or statutes to contest that point. So I don't think timing is the real issue here. Any contacts or misconduct by Sanyo, both for the purposes of
That's the point. What is being alleged now, I'm not talking about what we were talking about the first hour. I'm talking about now. That is telling people in an effort to suppress warranties that, hey, we're not going to come out like we said we would, or Sanyo said you would, come out and measure for you once you file a claim. You've got to measure it and present it to us before we'll lift a finger. That is clearly just Panasonic's conduct. So it's not a matter of imputing what Sanyo did. This is clearly aimed at who's ever administering the warranty program now. So it is now Panasonic's conduct. It's all in their court at this point. What is the basis of and so you can't use imputed, I don't think. So what would be the basis of California jurisdiction over such a misrepresentation claim or warranty suppression claim?
Just to be clear, is Your Honor referring to personal jurisdiction or extraterritoriality?
Well, personal to start with.
Okay, personal jurisdiction, as for Panasonic, we've argued that they waived the point. They say they did not waive the point because in our original complaint we had an additional allegation about Sanyo. That doesn't explain why Panasonic didn't challenge general personal jurisdiction then. It also doesn't explain why Panasonic didn't make the argument that there are insufficient contacts by Panasonic to California. An allegation about Sanyo has no relevance for Panasonic's jurisdiction unless jurisdictional contacts are imputed. So that's the personal jurisdiction aspect of it.
So you have a waiver argument. Any other on the merits? If there is no waiver, is there any other thing I should know?
Yes, Your Honor. I think there's either waiver or Panasonic has to concede the point that Sanyo's contacts are imputed to Panasonic for the purposes of personal jurisdiction. Otherwise, that's a point they could have made early on. And that isn't, in fact, the law. I don't believe there's binding case law on imputing contacts in the Ninth Circuit, but there's certainly persuasive case law throughout the Fourth, Fifth, and Tenth Circuits.
Usually you're imputing contacts where the conduct of the imputor, not the imputee, is what's at issue here. And I understand some of that may be in some of the other causes of action. For this cause, this particular claim, and I'll call it warranty suppression, I keep coming back, it is a Panasonic policy. There's no showing that Sanyo ever did this kind of thing.
I think the complaint doesn't really distinguish between Sanyo and Panasonic.
Well, but if the merger was in 2009, it's clear there's no pre-2009 warranty suppression. There's no allegation of that.
I think it was actually a little bit later than that, the merger and the disappearance of Sanyo.
No? Then when was it?
I believe it's at the front of our complaint, which I don't have on me.
No. Nonetheless, I don't see anything in the complaint where it's alleged that the practice of warranty suppression occurred while Sanyo was still around.
Again, I'm not sure that the amended complaint is limited in the timing of when this suppression policy started or ended.
Well, is there any allegation you can point me to when this practice started?
Again, Your Honor, I'm not sure we allege a specific date when it started. Certainly there are allegations in there that I can't point to at the moment, but they're in there of that it's been going on for quite some time. I mean, our client has been trying to deal with Sanyo/Panasonic for quite some time, so it's at least as long as that. And again, our position is that there is really no distinction between Sanyo and Panasonic for any purpose.
All right. Why don't you address the extraterritorial problem?
Yes, Your Honor. So we sort of addressed that in our opposition brief. I don't believe counsel came back in their reply. I don't have much to add to that beyond the fact that, again, Sanyo's contacts are imputed. So we're not actually alleging any extraterritorial application of California's statutes because the harms that we're alleging, or at least the misconduct, is occurring in California. We allege that Sanyo's headquarters were here. This is where they developed the warranty policy. This is where they designed it. This is where they implemented it. And this is where they processed warranty claims. So we're not seeking extraterritoriality of California law. We're seeking to enforce it based on conduct that's occurring in California.
Well, but the conduct in question is not the giving of the warranty, it's the breach of the warranty. And then following that, the kind of misrepresentations that constitutes warranty suppression. What's the evidence that, as it affects this plaintiff, that were policies and actions that were taken which originated in California?
We allege that Sanyo/Panasonic, the defendants, were actually processing the warranty claims in California.
Well, it was first submitted in 2016. For these plaintiffs, right? That's when they discovered the problem. That's when they first said, we got a problem with these 8 or 13 or 12. Then it took 18 months to get some resolution. It said, that was all 2016 and after. The merger was long before that, 2009. So is there any evidence that the handling of the warranty claim, for instance, and the 18 months it took to get around to it, and then denying relief as to the 4 or 5, took place in California?
Yes, Your Honor. I would point to footnote 12 on page 17, where we lay out all of the contacts Again, our complaint
Are
speaks
you talking about the brief or your complaint?
in the opposition, and in that footnote we cite to several paragraphs. But in our complaint, we don't really distinguish between Sanyo and Panasonic because for corporate purposes, for jurisdictional purposes, they're the same entity, having merged into Panasonic. So we don't distinguish that. I think we label defendants as Sanyo. Up front, we define defendants as, or Sanyo as defendants and vice versa. So we don't distinguish between Sanyo and Panasonic. So in those allegations, we're referring to Sanyo's misconduct in California. But what we're really referring to, the way we define Sanyo to mean defendants, is both Sanyo itself and Panasonic.
But with respect to the actual conduct that's at issue here, if it only occurred after the merger, you've got to look at where that misconduct occurred, right? I'm trying. Where was the decision made by decision makers? And I assume it's at Panasonic, not to honor the warranty.
California.
It was in California?
We define defendants, meaning both Sanyo and Panasonic, to mean Sanyo, and we just refer to Panasonic and Sanyo together in our complaint as Sanyo without distinguishing between the two. So when we allege that Sanyo's contacts and Sanyo's misconduct is occurring in California, based on the way we define Sanyo and the reasonable inference to draw from that, is that the misconduct is occurring by...
Other than through imputation, which I don't buy at this point given the timing, do you actually have evidence that there were decision makers at Panasonic that were operating and making decisions about enforcement of warranties and responding to warranties in California?
So just to clarify, at this point I'm not arguing that Sanyo's contacts are imputed. I'm making the point that we didn't distinguish between Sanyo and Panasonic. So our allegations about Sanyo...
I got to see whether there's something behind those allegations, because then you have a Rule 11 problem. Because you say in paragraph 12 that Panasonic is a Delaware corporation, principal place of business in Newark, New Jersey, wholly its subsidiary of Panasonic Corporation. What evidence is there, what allegation is there that the refusal to make good on the warranty was the result of decision-making that occurred in California?
So, again, our allegation is that these claims are processed in California. The first warranty that doesn't actually apply to our panels that we submitted in our first complaint, that lists a California address. Counsel today has complained that we sent it to the wrong California address, but we still should have sent our warranty complaints to California. Those are basically our allegations about...
Let me ask, your co-counsel said that this return address, this address that it was sent to, the original July 18th letter, was sent to Panasonic headquarters. So are you saying, now I am a little confused, is Panasonic operating in California as Panasonic?
Yes.
If they are doing business in California, they have a headquarters in California? I thought their headquarters was in New Jersey.
I'm not sure if it's corporate headquarters in California, but that is a Panasonic address, an existing Panasonic address.
And that's the address you claim that the to which the warranty demand or whatever it was, breach warranty notice, was sent and was received and processed?
Yes, Your Honor.
Is that alleged anywhere in the complaint?
We allege that they're processing the claims in California. We point out that we've been directed to mail our complaints to California. That would be the basis for that allegation.
What paragraph? Can you point to a paragraph that has that?
Perhaps we didn't attach of major buildings in which Panasonic operates here in California and San Diego in the former address of the Sanyo locations. And so they have major buildings and operations in... I've characterized them as headquarters. That may be inaccurate, but they're major offices.
But do we know that they're involved with solar panels? I mean, Panasonic does a lot of stuff. Well, do we know? I guess that's my question. When you got return mail, correspondence about the 8 and all that sort of stuff. Did it come from California? Did it come from New Jersey?
From Oregon.
Those are in the two warranties that we have. Those addresses are in California, and those addresses are.
Is there correspondence to your clients from Panasonic in response to the first complaint about the 12 or 13? Did any of Panasonic's correspondence come from California?
I'm not sure of that information.
Can I answer that question, Your Honor?
Yeah.
I think I know the answer.
Okay, what's
It's
the answer?
attached. There's some correspondence attached to their complaint. It's actually not the named plaintiffs. They point to another. The Ziccarellas, I believe, are the name of the other. But it was another warranty claim submitted by Power Overhaul. And the correspondence, what exhibit is it? Exhibit C to the first amended complaint indicates that the address is Oregon, which is where Panasonic handles the warranty claims processing. It's in the signature blocks.
Well,
to the
is it
correspondence.
your contention? Yeah, I see. It's Wilson View, Oregon.
It's my understanding that that's where warranty claims for the Dickerts were handled as well.
And is it your contention? I know now we're off the record. We're not in the record that's a written record before the court. But is it your understanding or contention that Panasonic's handling of the warranty, none of that occurs in California?
That is my understanding. For anything relevant to this case, the time period at issue with this case, I don't know about before the 2016 warranty claim, but at least by 2016 forward, the warranty claims were not being handled in California.
Now, if that were the case, what would be the basis of jurisdiction here, since you have an out-of-state buyer and warranty processing by an out-of-state and alleged breach of the warranty and alleged suppression of the warranty by an actor in Oregon? How does this court have jurisdiction over that?
So I don't think personal jurisdiction, again, is the problem. I think the problem there might be extraterritorial application.
Right. What about the extraterritorial application? What about that? That seems like UCL could not apply there. You'd have to apply the laws of the residents of at least one of the parties, it seems to me.
I think that would be true, Your Honor, and we certainly do allege violations of New Jersey statutes. So that would be true for the Dickerts. That would not be true for all members of the class. And just to reiterate that counsel today has been arguing that we should have sent notice to a different California address. I think that would be the basis for an argument, in addition to our allegations, that Sanyo/Panasonic is actually currently processing these claims in California, enough to establish that we're not seeking extraterritorial application of the UCL.
Right. What about that? Whatever the address should have been, either the bad one or the good one, they're both
So
California.
the law, we said a Frito-Lay decision in our brief with respect to the issue of extraterritoriality. The law is that statutes like the UCL and CLRA presumptively do not apply to occurrences outside California. And you have to look to where the misconduct and where the injury occurred for purposes of that analysis. The Dickerts are in New Jersey. Geogenics, who they bought solar panels from, is in New Jersey. The warranty claims that they're complaining about were processed in Oregon. And just pointing to some contact in California, even if there's like some address that we asked them to be sent to, doesn't overcome the presumption that the statutes don't apply extraterritorially to non-residents. I'd point, Your Honor, to a decision that you authored, Cannon versus Wells Fargo, which is 917 F sub 2D 1025 at page 1055, where you held that despite the fact that Wells Fargo had a principal place of business in California, that wasn't enough to establish that the law could be applied extraterritorially to non-residents in other jurisdictions in a class action, and you dismissed UCL, and I'm not sure, maybe CLRA claims as well. Same analysis would apply to the CLRA claims. If Your Honor would like, I'd also like to respond to the waiver argument.
Briefly.
Okay. The first amended complaint, the original complaint only asserted express warranty claims based on the limited warranty, a Song Beverly Warranty Act claim that was abandoned, and Magnuson Moss claims. And they had some implied warranty claims that were abandoned. Everything else was asserted for the first time in the first amended complaint. We could not have brought personal jurisdiction is claim by claim, and we could not have brought a personal jurisdiction as to a defense as to any of the other claims because they weren't asserted in the original complaint previously. With respect to the claims that were originally asserted, the express warranty claims, they first asserted the one based on the geogenics representations in the amended complaint. It was brand new. And they had alleged in their original complaint that the sale of the solar panels occurred in California. So we didn't have, when they removed that allegation in the amended complaint, we had a new basis for raising personal jurisdiction, a facial challenge that we didn't previously had. So at the very least, the personal jurisdiction defenses as to all the brand new claims, we obviously couldn't have raised any personal jurisdiction defenses as to those. Under international shoe, it's not just purposeful availment, by the way. The second step, they'd have to show specific forum-related conduct causing any of their injuries. They certainly don't meet step 2 of the international shoe analysis. There's no general, even if there are like buildings that they have pictures of Panasonic in California, that doesn't satisfy general jurisdiction under Baumler. Panasonic isn't at home in California. They allege that Panasonic's principal place of business is New Jersey. They don't establish that Panasonic's incorporated in New Jersey, and they don't allege that this is their principal place of business. So there's no general jurisdiction, and they can't meet specific jurisdiction under international shoe or BMS or any of the recent Supreme Court decisions with respect to specific jurisdiction.
Could I make 2 quick points, Your Honor?
Briefly.
General jurisdiction is not a claim-by-claim basis. There's no reason why Panasonic couldn't have asserted a challenge to general jurisdiction in its first motion. Second, the only different allegations were about Sanyo, not Panasonic. So to say that Panasonic could not have asserted personal jurisdiction challenges is to concede the point that Sanyo's contacts can be imputed to Panasonic, because otherwise those additional allegations or removal of allegations have nothing to do with Panasonic's personal jurisdiction.
What about your clarification now that some of the conduct you're looking at had to have only involved recent conduct by Panasonic, which is different from saying, well, these are defective products from day one, et cetera, et cetera. I mean, why shouldn't the court now look at it? I mean, I'm not sure it's fair to say whether they could have forecasted all this, because even coming into this hearing, I wasn't exactly sure what the allegations were. And now that it's clear that some of the allegations pertain to post-2016 conduct or misconduct, and that's a different set of players. And I'm not sure I think it's reasonable to imply a waiver under those circumstances, because now you look at, the imputation theory, which might have been accepted before, doesn't necessarily fly in this circumstance. So I'm not sure that the waiver, to the extent there's been any kind of a waiver argument, would apply to this now crystallized sort of post-2016 misconduct.
Your Honor, I don't think could be wrong, but I don't think that the amended complaint clarifies that the alleged misconduct took place after the merger any more than the original complaint. So these points were available to counsel in response to the original complaint. The original complaint was in time restricted, just like the amended complaint isn't as clear about timing. So those arguments were available before, and they were not asserted.
All right. I'm going to take the matter under submission, and I'm going to give this back to you, but you ought to hang on to that, because that might be relevant in terms of future proceedings in this matter.
Your Honor, may I pose a question?
Yeah.
Well, you're ready to get rid of this, but these motions to dismiss are very difficult for us as plaintiffs' counsel, obviously, because we're attempting to satisfy the elements of the causes of action, and we're struggling to get the sufficient evidence. Would you consider allowing us to take two brief depositions to the points that were raised here. Specifically, I'll just pose the question. I would like to take the depositions of the individuals that adjusted the claim of our client, because that person ostensibly was a warranty person, apparently in Oregon, and apparently whose bosses and so forth were in California. But I don't know that for sure. So
You're talking about jurisdictional discovery, essentially.
Yes, exactly. At this point, two discrete depositions of the two individuals, one of whom adjusted another claim that we have as part of our FAC, the Exhibit C. There was some emails exchanged, and this other individual named Sean Johnson. So that's, I would ask that, and we would do that.
To determine what exactly?
Well, I mean, to determine, who makes the decisions, and where do they make the decisions from? If you don't think it's necessary, or the alternative, we'd ask for leave to amend. But I always struggle with this idea of, like, at which point, what would be an efficient way to get a little more evidence in order to, assert our claim. Anyway, that's what I would request you to consider, Your Honor.
All right. You're essentially requesting jurisdictional discovery at this point. All right. I'll take that into submission as well.
Thank you.
Thank you.